they made some comments about whether a document which was reformatted for publication in a newspaper was authentic or not. No one has said, we've come forward with the evidence, overwhelming evidence, that the Grand Rebbe spoke personally to members of the congregation. The board, you have in the record the findings by the senior judges of the ecclesiastical court. These were people that were put in place well before this dispute broke out. Two of the judges were appointed by the first founding Grand Rebbe, Joel Teitelbaum.
And aren't you, when you make these arguments to us, aren't you asking us to decide ecclesiastical questions?
I think that that's what they are doing. I am saying that there are ecclesiastical questions that it's impossible to say whether the election was appropriate or not appropriate. You have to determine.
Well, I mean, a lot of...
Was somebody... I'm sorry.
I guess what's bothering me is this. A lot of these cases involve hierarchical churches in which there's a highest body of the church that everyone recognizes is the highest body of the church, and there's law that says the courts won't interfere with that unless they can do it on neutral principles. This is not a hierarchical religious organization. This is essentially a congregational organization. There's a schism within the congregation. Who are we supposed to defer to? You say we defer to the rabbis, but they say, oh, no, those are their rabbis. Defer to our rabbis. How are we supposed to know?
Well, the difference is that there's not 4,500 pages of record, and there's not a single document that contests that the four senior judges were in place well before the dispute, two of whom were appointed by the original founding rabbi, Joel Teitelbaum, and two by Moshe Teitelbaum for many, many years. What you have is a snide comment in a brief that says that we're referring to unelected rabbis who are compensated by the congregation. In response, you have a document they put in by some organization we never heard, never named who the judges were. It wasn't attached to an affirmation. It didn't comply with this, didn't have a translation.
I mean, you keep saying the evidence is all on your side, but isn't this this issue in itself the sort of thing a court should be uncomfortable deciding? I mean, you're almost saying our rabbis are kosher, their rabbis are not kosher.
The Supreme Court of the United States in Serbian and all the other cases, and frankly the other decisions of this court have said, and cases around the country, federal and state, including interesting decision by Justice McLaughlin, who now is on the Second Circuit, former Dean of Fordham, in the Scholar Rabbi case, someone who was not shy about getting involved in disputes. He said, in order to evaluate competing claims for succession and power, it's impossible, in essence, to do it without determining were these people members. If they were told by the Grand Rebbe, you're out, he couldn't have called. Beryl Friedman, I'm sitting
here.
They
said take him out of the equation entirely.
Yes, I'm the only attorney that's lived with this from the inception in August of 2001. I'm hearing for the first time Beryl Friedman is not part of this
but
case.
I take it, Mr. Mullen, to agree with you, we have to accept the proposition that the Grand Rebbe has ordained all of this, right?
You have to accept the proposition that in order to determine this case, you have to get involved in matters of church discipline and governance. And if you realize...
I know that's your bottom line, but I'm saying we have to say that the Grand Rebbe ordained this so that you don't look at the bylaws at all.
I will accept Justice Barish's decision and the decision of the appellate division, which said both courts said we cannot get involved because it's impossible to get involved here.
Assume they had succeeded in proving. I understand you say they didn't and they didn't even raise an issue. But suppose they had succeeded in proving that wasn't the Grand Rebbe's voice on the speakerphone. What should we do then?
Wouldn't matter because, number one, you had written certification. You had written certification by the Grand Rebbe.
Let me ask my point more broadly. Suppose they were able to raise an issue of fact as to what the Grand Rebbe's position was. What should happen?
In order to do that, you still have to get involved in what the Supreme Court...
But how should we decide the case on my assumption?
That you should affirm the appellate division that the civil courts cannot get involved in governance. This is a governance
So
issue.
the case is just plain non-justiciable. It doesn't matter whether we know what the Grand Rebbe said or whether we don't know what he said. The defendant wins. Whoever the defendant is, the defendant wins because it's non-justiciable. Is that your position?
Judge, I have probably close to 60,000 people who would hope that this court would issue a ruling affirming the Grand Rebbe's, specifically endorsing the Grand Rebbe's finding. I realize that this court...
And how many does Mr. Novak have?
Well, I won't go down that...
I mean, isn't it a schism, a split?
It's clear schism. The key point is this, that it is a church governance. It's internal governance and discipline.
If Mr. Novak came in with this affidavit that I was looking for from you,
Right.
that said, regardless of anything Mr. Mullen says, I say that this person is the head of this thing, it's over.
Right. Under our bylaws, that is an ecclesiastical, the highest ecclesiastical ruling, and it is over. And our position is, we have overwhelming evidence in the record. We have written, there's nothing contradicting that says the Grand Rebbe, okay, they attacked the telephone conversation.
The second
Let's
part
take that out. Look at all
Mr.
the
Mullen,
other evidence.
the second part of my question is that I think that's true too, but I think that bringing in affidavits is bringing it into a court, and based on neutral principles and looking at the bylaws, we can decide it. Your argument seems to be not the way you answered my question. You should say there should be no affidavit from the Grand Rebbe. You shouldn't even be looking at this case. You should have thrown it out the minute you saw the petition because you saw the names of the parties involved.
Well, not because of the names of the parties. I think because, as Judge Kaye and other members of the court, Judge Parrick, have been involved in some earlier cases, if it could truly be decided, for instance, in the B'nai Jacob case, you had a pure real estate issue. You had a fight where there was a document where parties had entered into an agreement and said, you'll occupy this amount of space, here's the term, here's the price, here's the square footage. So therefore, there's no question that if it was truly a neutral principle of law issue, the court could get involved. But here, you have, let me tell you...
But just to follow up on that, don't you say that the Grand Rebbe decides all of that stuff, so even that would be wrongly decided?
The answer is, under our bylaws, that's correct. If you are a true satmar, if you are remaining a member of this voluntary association, you do not go to civil court if two members of the sect have a civil dispute. There's an implied consent to a form of governance. You cannot join an organization that's founded on a fundamental principle that decisions are decided by rabbinical ecclesiastical authorities and say you're a member.
Assuming that to be true, what's the consequence for us? Are we bound by that? And we can't decide the case because your clients consider it sinful to go to civil court?
No. If in fact, Judge, the dispute itself could be decided by neutral principles of law, such as the real estate dispute in the B'nai Jacob case, then the court could get involved.
Well, why wasn't the discussion I was having with Mr. Novak about a neutral principle? I said you can't count to 51. He says, yes, I can. It's right here. Well, that seemed non-ecclesiastical.
Well, if in fact to be a member under our bylaws, you had to be in Brooklyn and you had to pay $50, those are neutral principles of law. But when you have bylaws that say you can't be a member unless you live according to Torah, which civil judge wants to decide whether somebody is a sufficiently observant Catholic, Protestant, or Jew living close enough to Torah, or observing the Sabbath when the Jews can't agree among themselves as to what it means to observe the Sabbath? Some start at one time, some start another time, some have something called an Eruv, which allows you to have certain activities, not other activities. Who detests the membership, accepting the leadership? Let's look at what Rabbi Aaron said. Don't look at what we're saying.
You know, you do have a red light.
Okay, if I could just finish this one point, and there's this. Aaron expelled members of his own congregation because they didn't listen to the Rebbe and his designees. Beryl Friedman, at his meeting on January 14th, said if the Rebbe says there's no election, at page A109, if the Rebbe says there's no election, there will be no election. So all this talk about the niceties of corporate management, maintenance of all records and whether notice was given. And the Kunstzus itself is a critical document because Beryl Friedman then acknowledged not only is Zalman the chief rabbi, but he's chief of the rabbinical court.
Thank you.
And he signed it.
Thank you.
Thank you
Mr.
for your
Novak?
patience, Your Honor.